This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Welcome to the third season of Murgatroyd's Innovation Talks podcasts. We're delighted you've joined us. If you have any questions, please get in touch by email at innovation.talks@murgatroyd.com or via @Murgatroyd on Twitter. Don't forget to subscribe to make sure you don't miss any future episodes. So let's go straight into today's podcast.
Hi there, I'm Catherine Bonner. I'm Director Patents here in Murgatroyd's Southampton office, and I'm here today with Rebecca Dobson, Senior Trademark Attorney at Murgatroyd Southampton office.
Hi, Catherine.
Great to be sitting down with you, Rebecca. Today, we're going to speak about intellectual property and, in particular, what to do if someone copies your intellectual property or if you suspect that someone is copying your intellectual property. Rebecca, as a trademark attorney, I think you must have lots of experience of this with direct trademarks and designs.
Absolutely. Trademarks is one of the major things we come across. It's people either using identical marks for identical goods or services, but also just confusingly similar, which is a terminology that we use for trademarks. So sufficient that your customers, there is either actual confusion or potential confusion. And our job is to help you through the steps that are needed to identify what your options are and how to go about trying to detangle the situation.
Yes, so I think we can say that there are some necessary steps. If you think someone is copying your intellectual property, if you have an idea or someone's mentioned this to you, first of all, the important thing is to gather evidence. It's not enough for it to be hearsay. It has to be facts that you're obtaining. So you have all of your evidence lined up. And I think second point would be seek advice. Nothing is too terrible to talk about. Whatever you've found, we'd be happy to discuss it with you, both from I handle mainly patents and design matters. Rebecca, I know you're mainly trademarks. So let's give some further details about this evidence that's needed and the next steps.
Well, the first thing is to really pinpoint what it is that you think they've copied, and hence that very much relates to how much action is required from our perspective and yours. So firstly, our job is to look at the evidence that you've accrued and look at how they're using it, but also do that in comparison to your IP portfolio and looking at the rights that you actually have and how those could have been infringed. Now, in some instances, infringement hasn't occurred because, for example, they may be using a very similar colour on their website, but actually everyone is free to use that colour. You don't own the exclusive rights to it. Equally, there can be a mark that is absolutely identical, and there's action that can be taken, and generally quite simple action. It doesn't have to be enormously aggressive or lengthy. It can be quite a swift resolution of the issue. So the first thing is to, as Catherine says, is pick up the evidence and have a good look at it in comparison to what you've got, and then put it in front of us and see what we can do about it.
Examples of suitable evidence for a potential where someone's copied a patent right that you might have. We'd need evidence of the alleged infringing product. So how it works, the functionality, the steps, if it's a piece of computer code or a piece of operational material. If it's an actual product, then the parts of the product broken down. So we need an item to check through, really. If it's a design, you think someone's copied some intellectual property you have in a design, again, we need to see that design object. A link to a page where it's being sold, for example, evidence from display or offer for sale at a trade show, perhaps a article in trade press or a magazine, but gathering the evidence, particularly potentially dated evidence, is really important. Same for trademarks.
Absolutely. I think one of my favourite ones is in trying to gather evidence was a client who presented me with a photo of himself in the first product, aged, I think it was 2, in the first product that his dad had made with the mark absolutely on the product. So I always told the client that I was going to present him as Exhibit A, because if this is the person who is sitting in that box, then here is my Exhibit A. He's clearly a lot older than that now. So it's collecting that evidence, and as you say, sometimes it can be a difficult process because a lot of it can be historic. So both to accrue your rights as well as potentially historic infringement. We live in a world where the potential for infringement has come a lot easier to be aware of people infringing through the internet or what have you, whereas before, if you were a hairdresser in Plymouth and there was a similar hairdresser with a similar name in Newcastle, you probably never know about each other. In this day and age, websites, you can find each other quite easily. So it is something to be increasingly aware of, and historic data can be relevant too, which I'm sure is the same with patents. You've got to have a traceability of that invention and how and when it was developed to show your rights to it.
Yeah, absolutely. I think some examples might be useful. So I have a fishing product that has been copied. So with that was a patented matter. So the material we found was website evidence, and that the next steps were to talk to the other side, to make them understand that they were infringing, that they had copied our intellectual property, and that they should therefore not be selling their product in our marketplace, in the area that we had the patent rights in. So that was an interesting one with hopefully a good solution there. So examples?
Well, I was just going to say, it's also important to realise that sometimes this infringement isn't actually intentional. Sometimes it's purely innocent. It's two people have come up with the same idea or whatever, and it really does come down to who came up with the idea, whether the design or whatever it was first. So it doesn't have to be a particularly aggressive or intentional move, but our job is to help clients work out how to untangle that. And it doesn't have to be, as you say, it's either explaining that you own the rights and please stop. It can be as simple as just cutting off the market. We had a client who we put in place customs notices based on their trademark registrations around the world, and that was enough to stop a Chinese distributor. No, it didn't get damages and things like that, but it achieved what the client wanted, which was stopping that distributor, ex-distributor, taking their customers and using their framework, which was hard-earned and a lot of investment in it. So it doesn't have to be aggressive. It doesn't have to be particularly expensive in many cases. It's about the subjectivity and the commerciality of that infringement and what it's worth to you.
Yes, goes without saying, though, you need to have intellectual property, and increasingly now you need to have registered intellectual property rights before any of these discussions can start. If somebody copies your IP, the first thing we need to look at is your existing IP portfolio. We can help with building IP portfolios, but it's really important, I think, to have those logged, up to date and relevant to your business and your business now.
Trademarks, of course, you've got the registered rights, but there's unregistered rights can sometimes be as important if we're trying to argue a passing off case or something like that. And that is absolutely key, to keep a record of your use and your examples of how you have used that mark over the years to demonstrate that you've got goodwill and reputation. Because if we can't demonstrate goodwill and reputation for that period of time, then something that isn't necessarily infringement of a trademark registration could be passing off. And if we don't have that evidence accrued, we could fail at the first hurdle on that. So recording of IP, as you rightly say, is vitally important on all fronts. And I think design registration as well, that's equally as important to keep that traceability, isn't it?
Yes, designs are useful if you've got them registered, if you've got them recorded. It's always really great. What I say about design is a picture's worth 1,000 words. I can write a beautiful patent application, get it granted. It's, 25, 250 pages long, and then you're trying to enforce that in an overseas country. I think having a design registration where it clearly sets out the shape, the product that you're trying to protect can be really, really powerful. Yes, we've had product taken off the market overseas in a number of territories that I can think of, all due to a design registration. There were patent applications and patents that existed for that product, but it was the power of the design registration was in the picture, that you didn't need translation services to understand the picture.
Yeah, sometimes the dealing with international based IP rights can be interesting, can't it? But the lovely thing of a picture, same with the trademark registrations and things like that, sometimes you don't actually have to understand what the words are. You can see a direct copy, if intentional or otherwise, but if it raises confusion in the customers, then it needs to be stopped.
Yes, yeah, absolutely. We're always happy to help and to advise, or even just to have a chat with people who think that they might have had their intellectual property rights copied. Maybe there hasn't been a copy, maybe there has. Maybe there's enough evidence, maybe there's not. But we're always happy to have a chat, aren't we?
Absolutely. Very important to come first of all and clarify before taking any further steps.
Yeah, absolutely. Thank you, Rebecca, for sharing your experience. It's been really good to talk things through.
Thank you.
And we'll talk again.
Absolutely.
Thanks for your time today. We hope you found today's podcast valuable. And don't forget to subscribe to make sure you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.